Rome Statute of the International Criminal Court, the trial. Part 6. The trial. Article 62. Place of trial. Unless otherwise decided, the place of the trial shall be the seat of the court. Article 63. Trial in the presence of the accused. 1. The accused shall be present during the trial. 2. If the accused, being present before the court, continues to disrupt the trial chamber may remove the accused and shall make provision for him or her to observe the trial and instruct counsel from outside the courtroom, through the use of communications technology, if required. Such measures shall be taken only in exceptional circumstances after other reasonable alternatives have proved inadequate, and only for such duration as is strictly required. Article 64. Functions and powers of the trial chamber. 1. The functions and powers of the trial chamber set out in this article shall be exercised in accordance with this statute and the rules of procedure and evidence. 2. The trial chamber shall ensure that a trial is fair and expeditious and is conducted with full respect for the rights of the accused and due regard for the protection of victims and witnesses. 3. Upon assignment of a case for trial in accordance with this statute, the trial chamber assigned to deal with the case shall a. Confer with the parties and adopt such procedures as are necessary to facilitate the fair and expeditious conduct of the proceedings. b. Determine the language or languages to be used at trial, and c. Subject to any other relevant provisions of this statute, provide for disclosure of documents or information not previously disclosed, sufficiently in advance of the commencement of the trial, to enable adequate preparation for trial. 4. The trial chamber may, if necessary for its effective and fair functioning, refer preliminary issues to the pre-trial chamber or, if necessary, to another available judge of the pre-trial division. 5. Upon notice to the parties, the trial chamber may, as appropriate, direct that there be joinder or severance in respective charges against more than one accused. 6. In performing its functions prior to trial or during the course of a trial, the trial chamber may, as necessary, a. Exercise any functions of the pre-trial chamber referred to in Article 61, paragraph 11. b. Require the attendance and testimony of witnesses and production of documents and other evidence by obtaining, if necessary, the assistance of states as provided in this statute. c. Provide for the protection of confidential information. d. Order the production of evidence in addition to that already collected prior to the trial or presented during the trial by the parties. e. Provide for the protection of the accused, witnesses, and victims, and f. Rule on any other relevant matters. 7. The trial shall be held in public. The trial chamber may, however, determine that special circumstances require that certain proceedings be in closed session for the purposes set forth in Article 68, or to protect confidential or sensitive information to be given in evidence. 8. A. At the commencement of the trial chamber shall have read to the accused the charges previously confirmed by the pretrial chamber. The trial chamber shall satisfy itself that the accused understands the nature of the charges. It shall afford him or her the opportunity to make an admission of guilt in accordance with Article 65 or to plead not guilty. b. At the trial, the presiding judge may give directions for the conduct of proceedings, including to ensure that they are conducted in a fair and impartial manner. Subject to any directions of the presiding judge, the parties may submit evidence in accordance with the provisions of this statute. 9. The trial chamber shall have, inter alia, the power on application of a party or on its own motion to a. Rule on the admissibility or relevance of evidence, and b. Take all necessary steps to maintain order in the course of a hearing. 10. The trial chamber shall ensure that a complete record of the trial, which accurately reflects the proceedings, is made and that it is maintained and preserved by the registrar. Article 65. Proceedings on an admission of guilt. 1. Where the accused makes an admission of guilt pursuant to Article 64, Paragraph 8, a. The trial chamber shall determine whether a. The accused understands the nature and consequences of the admission of guilt. b. The admission is voluntarily made by the accused after sufficient consultation with defense counsel, and c. The admission of guilt is supported by the facts of the case that are contained in I. The charges brought by the prosecutor and admitted by the accused. 2. Any materials presented by the prosecutor which supplement the charges and which the accused accepts, and 3. Any other evidence, such as the testimony of witnesses, presented by the prosecutor or the accused. 2. Where the trial chamber is satisfied that the matters referred to in paragraph 1 are established, it shall consider the admission of guilt, together with any additional evidence presented, as establishing all the essential facts that are required to prove the crime to which the admission of guilt relates, and may convict the accused of that crime. 3. Where the trial chamber is not satisfied that the matters referred to in paragraph 1 are established, it shall consider the admission of guilt as not having been made, in which case it shall order that the trial be continued under the ordinary trial procedures provided by this statute and may remit the case to another trial chamber. 4. Where the trial chamber is of the opinion that a more complete presentation of the facts of the case is required in the interests of justice, in particular the interests of the victims, the trial chamber may a. Request the prosecutor to present additional evidence, including the testimony of witnesses, or b. Order that the trial be continued under the ordinary trial procedures provided by this statute, in which case it shall consider the admission of guilt as not having been made and may remit the case to another trial chamber. 5. Any discussions between the prosecutor and the defense regarding modification of the charges, the admission of guilt or the penalty to be imposed shall not be binding on the court. Article 66. Presumption of innocence. 1. Everyone shall be presumed innocent until proved guilty before the court in accordance with the applicable law. 2. The onus is on the prosecutor to prove the guilt of the accused. 3. In order to convict the accused, the court must be convinced of the guilt of the accused beyond reasonable doubt. Article 67. Rights of the accused. 1. In the determination of any charge, the accused shall be entitled to a public hearing, having regard to the provisions of this statute, to a fair hearing conducted impartially, and to the following minimum guarantees, in full equality. A. To be informed promptly and in detail of the nature, cause and content of the charge, in a language which the accused fully understands and speaks. B. To have adequate time and facilities for the preparation of the defense and to communicate freely with counsel of the accused choosing in confidence. C. To be tried without undue delay. D. Subject to Article 63, Paragraph 2, to be present at the trial, to conduct the defense in person or through legal assistance of the accused choosing, to be informed, if the accused does not have legal assistance, of this right and to have legal assistance assigned by the court in any case where the interests of justice so require, and without payment if the accused lacks sufficient means to pay for it. E. To examine, or have examined, the witnesses against him or her and to obtain the attendance and examination of witnesses on his or her behalf under the same conditions as witnesses against him or her. The accused shall also be entitled to raise defenses, and to present other evidence admissible under the statute. F. To have, free of any cost, the assistance of a competent interpreter and such translations as are necessary to meet the requirements of fairness, if any of the proceedings of or documents presented to the court are not in a language which the accused fully understands and speaks. G. Not to be compelled to testify or to confess guilt and to remain silent, without such silence being a consideration in the determination of guilt or innocence. H. To make an unsworn oral or written statement in his or her defense, and I. Not to have imposed on him or her any reversal of the burden of proof or any onus of rebuttal. 2. In addition to any other disclosure provided for in this statute, the prosecutor shall, as soon as practicable, disclose to the defense evidence in the prosecutor's possession or control which he or she believes shows or tends to show the innocence of the accused, or to mitigate the guilt of the accused, or which may affect the credibility of prosecution evidence. In case of doubt as to the application of this paragraph, the court shall decide. Article 68. Protection of the victims and witnesses, and their participation in the proceedings. 1. The court shall take appropriate measures to protect the safety, physical and psychological well-being, dignity, and privacy of victims and witnesses. In so doing, the court shall have regard to all relevant factors, including age, gender as defined in Article 7, Paragraph 3, and health, and the nature of the crime in particular, but not limited to, where the crime involves sexual or gender violence or violence against children. The prosecutor shall take such measures, particularly during the investigation and prosecution of such crimes. These measures shall not be prejudicial to or inconsistent with the rights of the accused and a fair and impartial trial. 2. As an exception to the principle of public hearings provided for in Article 67, the chambers of the court may, to protect victims and witnesses or an accused, conduct any part of the proceedings in camera or allow the presentation of evidence by electronic or other special means. In particular, such measures shall be implemented in the case of a victim of sexual violence or a child who is a victim or a witness, unless otherwise ordered by the court, having regard to all the circumstances, particularly the views of the victim or witness. 3. Where the personal interests of the victims are affected, the court shall permit their views and concerns to be presented and considered at stages of the proceedings determined to be appropriate by the court and in a manner which is not prejudicial to or inconsistent with the rights of the accused and a fair and impartial trial. Such views and concerns may be presented by the legal representatives of the victims where the court considers it appropriate, in accordance with the rules of procedure and evidence. 4. The Victims and Witnesses Unit may advise the prosecutor and the court on appropriate protective measures, security arrangements, counseling and assistance as referred to in Article 43, Paragraph 6. 5. Where the disclosure of evidence or information pursuant to this statute may lead to the grave endangerment of the security of a witness or his or her family, the prosecutor may, for the purposes of any proceedings conducted prior to the commencement of the trial, withhold such evidence or information and instead submit a summary thereof. Such measures shall be exercised in a manner which is not prejudicial to or inconsistent with the rights of the accused and a fair and impartial trial. 6. A state may make an application for necessary measures to be taken in respect of the protection of its servants or agents and the protection of confidential or sensitive information. Article 69. Evidence. 1. Before testifying, each witness shall, in accordance with the rules of procedure and evidence, give an undertaking as to the truthfulness of the evidence to be given by that witness. 2. The testimony of a witness at trial shall be given in person, except to the extent provided by the measures set forth in Article 68 or in the rules of procedure and evidence. The court may also permit the giving of viva voce, oral, or recorded testimony of a witness by means of video or audio technology, as well as the introduction of documents or written transcripts, subject to this statute and in accordance with the rules of procedure and evidence. These measures shall not be prejudicial to or inconsistent with the rights of the accused. 3. The parties may submit evidence relevant to the case, in accordance with Article 64. The court shall have the authority to request the submission of all evidence that it considers necessary for the determination of the truth. 4. The court may rule on the relevance or admissibility of any evidence, taking into account, inter alia, the probative value of the evidence and any prejudice that such evidence may cause to a fair trial or to a fair evaluation of the testimony of a witness. In accordance with the rules of procedure and evidence. 5. The court shall respect and observe privileges on confidentiality as provided for in the rules of procedure and evidence. 6. The court shall not require proof of facts of common knowledge, but may take judicial notice of them. 7. Evidence obtained by means of a violation of this statute or internationally recognized human rights shall not be admissible if a. The violation casts substantial doubt on the reliability of the evidence, or b. The admission of the evidence would be antithetical to and would seriously damage the integrity of the proceedings. 8. When deciding on the relevance or admissibility of evidence collected by a state, the court shall not rule on the application of the state's national law. Article 70. Offences against the administration of justice. 1. The court shall have jurisdiction over the following offences against its administration of justice when committed intentionally. A. Giving false testimony when under an obligation pursuant to Article 69, Paragraph 1, to tell the truth. B. Presenting evidence that the party knows is false or forged. C. Corruptly influencing a witness, obstructing or interfering with the attendance or testimony of a witness, retaliating against a witness for giving testimony or destroying, tampering with or interfering with the collection of evidence. D. Impeding, intimidating or corruptly influencing an official of the court for the purpose of forcing or persuading the official not to perform, or to perform improperly, his or her duties. E. Retaliating against an official of the court on account of duties performed by that or another official. F. Soliciting or accepting a bribe as an official of the court in connection with his or her official duties. 2. The principles and procedures governing the court's exercise of jurisdiction over offences under this article shall be those provided for in the rules of procedure and evidence. The conditions for providing international cooperation to the court with respect to its proceedings under this article shall be governed by the domestic laws of the requested state. 3. In the event of conviction, the court may impose a term of imprisonment not exceeding 5 years, or a fine in accordance with the rules of procedure and evidence, or both. 4a. Each state party shall extend its criminal laws penalizing offences against the integrity of its own investigative or judicial process to offences against the administration of justice referred to in this article, committed on its territory, or by one of its nationals. b. Upon request by the court, whenever it deems it proper, the state party shall submit the case to its competent authorities for the purpose of prosecution. Those authorities shall treat such cases with diligence and devote sufficient resources to enable them to be conducted effectively. Article 71. Sanctions for misconduct before the court. 1. The court may sanction persons present before it who commit misconduct, including disruption of its proceedings or deliberate refusal to comply with its directions, by administrative measures other than imprisonment, such as temporary or permanent removal from the courtroom. A fine or other similar measures provided for in the rules of procedure and evidence. 2. The procedures governing the imposition of the measures set forth in paragraph 1 shall be those provided for in the rules of procedure and evidence. Article 72. Protection of national security information. 1. This article applies in any case where the disclosure of the information or documents of a state would, in the opinion of that state, prejudice its national security interests. Such cases include those falling within the scope of Article 56, paragraphs 2 and 3, Article 61, paragraph 3, Article 64, paragraph 3, Article 67, paragraph 2, Article 68, paragraph 6, Article 87, paragraph 6 and Article 93, as well as cases arising at any other stage of the proceedings where such disclosure may be at issue. 2. This article shall also apply when a person who has been requested to give information or evidence has refused to do so or has referred the matter to the state on the ground that disclosure would prejudice the national security interests of a state and the state concerned confirms that it is of the opinion that disclosure would prejudice its national security interests. 3. Nothing in this article shall prejudice the requirements of confidentiality applicable under Article 54. Paragraph 3, E, and F, or the application of Article 73. 4. If a state learns that information or documents of the state are being, or are likely to be, disclosed at any stage of the proceedings, and it is of the opinion that disclosure would prejudice its national security interests, that state shall have the right to intervene in order to obtain resolution of the issue in accordance with this article. 5. If, in the opinion of a state, disclosure of information would prejudice its national security interests, all reasonable steps will be taken by the state, acting in conjunction with the prosecutor, the defense or the pretrial chamber or trial chamber, as the case may be, to seek to resolve the matter by cooperative means. Such steps may include a. Modification or clarification of the request. B. A determination by the court regarding the relevance of the information or evidence sought, or a determination as to whether the evidence, though relevant, could be or has been obtained from a source other than the requested state. C. Obtaining the information or evidence from a different source or in a different form, or D. Agreement on conditions under which the assistance could be provided including, among other things, providing summaries or redactions, limitations on disclosure, use of in-camera or ex parte proceedings, or other protective measures permissible under the statute and the rules of procedure and evidence. 6. Once all reasonable steps have been taken to resolve the matter through cooperative means, and if the state considers that there are no means or conditions under which the information or documents could be provided or disclosed without prejudice to its national security interests, it shall so notify the prosecutor or the court of the specific reasons for its decision, unless a specific description of the reasons would itself necessarily result in such prejudice to the state's national security interests. 7. Thereafter, if the court determines that the evidence is relevant and necessary for the establishment of the guilt or innocence of the accused, the court may undertake the following actions. A. Where disclosure of the information or document is sought pursuant to a request for cooperation under Part 9 or the circumstances described in paragraph 2, and the state has invoked the ground for refusal referred to in Article 93, paragraph 4, I, the court may, before making any conclusion referred to in subparagraph 7, A, 2, request further consultations for the purpose of considering the state's representations, which may include, as appropriate, hearings in camera and ex parte. 2. If the court concludes that, by invoking the ground for refusal under Article 93, paragraph 4, in the circumstances of the case, the requested state is not acting in accordance with its obligations under this statute, the court may refer the matter in accordance with Article 87. Paragraph 7, specifying the reasons for its conclusion, and 3. The court may make such inference in the trial of the accused as to the existence or non-existence of a fact, as may be appropriate in the circumstances, or b. In all other circumstances. I. Order disclosure, or 2. To the extent it does not order disclosure, make such inference in the trial of the accused as to the existence or non-existence of a fact, as may be appropriate in the circumstances. Article 73. Third-party information or documents. If a state party is requested by the court to provide a document or information in its custody, possession or control, which was disclosed to it in confidence by a state, intergovernmental organization or international organization, it shall seek the consent of the originator to disclose that document or information. If the originator is a state party, it shall either consent to disclosure of the information or document or undertake to resolve the issue of disclosure with the court, subject to the provisions of Article 72. If the originator is not a state party and refuses to consent to disclosure, the requested state shall inform the court that it is unable to provide the document or information because of a pre-existing obligation of confidentiality to the originator. Article 74. Requirements for the decision. 1. All the judges of the trial chamber shall be present at each stage of the trial and throughout their deliberations. The Presidency may, on a case-by-case basis, designate, as available, one or more alternate judges to be present at each stage of the trial and to replace a member of the trial chamber if that member is unable to continue attending. 2. The trial chamber's decision shall be based on its evaluation of the evidence and the entire proceedings. The decision shall not exceed the facts and circumstances described in the charges and any amendments to the charges. The court may base its decision only on evidence submitted and discussed before it at the trial. 3. The judges shall attempt to achieve unanimity in their decision, failing which the decision shall be taken by a majority of the judges. 4. The deliberations of the trial chamber shall remain secret. 5. The decision shall be in writing and shall contain a full and reasoned statement of the trial chamber's findings on the evidence and conclusions. The trial chamber shall issue one decision. When there is no unanimity, the trial chamber's decision shall contain the views of the majority and the minority. The decision or a summary thereof shall be delivered in open court. Article 75. Reparations to victims. 1. The court shall establish principles relating to reparations to, or in respect of, victims, including restitution, compensation and rehabilitation. On this basis, in its decision the court may, either upon request or on its own motion in exceptional circumstances, determine the scope and extent of any damage, loss and injury to, or in respect of, victims and will state the principles on which it is acting. 2. The court may make an order directly against a convicted person specifying appropriate reparations to, or in respect of, victims, including restitution, compensation and rehabilitation. Where appropriate, the court may order that the award for reparations be made through the trust fund provided for in Article 79. 3. Before making an order under this article, the court may invite and shall take account of representations from or on behalf of the convicted person, victims, other interested persons or interested states. 4. In exercising its power under this article, the court may, after a person is convicted of a crime within the jurisdiction of the court, determine whether, in order to give effect to an order which it may make under this article, it is necessary to seek measures under Article 93, Paragraph 1. 5. A state party shall give effect to a decision under this article as if the provisions of Article 109 were applicable to this article. 6. Nothing in this article shall be interpreted as prejudicing the rights of victims under national or international law. Article 76. Sentencing. 1. In the event of a conviction, the trial chamber shall consider the appropriate sentence to be imposed and shall take into account the evidence presented and submissions made during the trial that are relevant to the sentence. 2. Except where Article 65 applies and before the completion of the trial chamber may on its own motion and shall, at the request of the prosecutor or the accused, hold a further hearing to hear any additional evidence or submissions relevant to the sentence, in accordance with the rules of procedure and evidence. 3. Where paragraph 2 applies, any representations under Article 75 shall be heard during the further hearing referred to in paragraph 2 and, if necessary, during any additional hearing. 4. The sentence shall be pronounced in public and, wherever possible, in the presence of the accused.